Before anything else, I will introduce myself. I am Dr. Ntina Tzouvala, and I'm a senior lecturer here at the ANU College of Law, and I'm the convener of this series, which is entitled The Politics of International Law, and takes place under the auspices of the Center of International and Public Law here at the ANU. Also, I want to acknowledge that today I am on the country of the Naragal and Gambri people, and I want to pay my respects to elders past, present, and emerging, as well as to any Indigenous people who might be joining us today on this meeting. And I want, of course, to acknowledge that sovereignty over these lands has never been lawfully ceded, and to acknowledge the special burden and responsibility that comes with being in the law school in order to confront this reality of unceded sovereignty. Today, I'm very excited to welcome two fantastic researchers and scholars. Dr. Sara Seck is our guest speaker for the day. Dr. Seck is an associate professor and also an associate dean for research at the Schulich School of Law. Her research covers a broad area of topics, including business and human rights, sustainable development, and climate justice. And in fact, she co-edited the very recently published Cambridge Handbook of Environmental Justice and Sustainable Development that only, I think, came out in 2021. And she's the author of a number of articles and chapters on the broader issues I've mentioned so far, including, and I will put it on the chat in a minute, including her piece, Revisiting Transnational Corporations and Extractive Industries, Climate Justice, Feminism, and State Sovereignty, that appeared in 2017 in Transnational Law and Contemporary Problems. And I'm mentioning this piece because actually I have taught this piece, and I think it's fantastic, and I also think it teaches beautifully. So I'm going to share it with everyone in case, if they haven't done so, to do so in the future. And Sara will be talking today in the intersection of her interests about international law and the relational, ecologically embedded individual. She will be in conversation with Dr. Cassandra, who's a senior lecturer here at the ANU College of Law. She's down the corridor. Don't be fooled by her beautiful background. So she's my colleague here at the College of Law, and she's also a mission specialist with the ANU Institute of Space, and her work very much focuses on international law and space. She's also the co-editor of the recently published War and Peace in Outer Space, Ethics, Law and Policy, that was published in late 2020 by Oxford University Press. And she has also a very solid background in international criminal law, and her earlier work, including her 2017 book, was on international criminal law. And I thought this would be a really interesting discussion to be had, because currently Cassandra, well, for a number of reasons, but also including for the fact that currently Cassandra is developing a new project on embedding Indigenous knowledge into space governance and international law pertaining to space. So I thought that there could be some very interesting conversations to be had here between Sara and Cassandra. We are going to follow today our usual structure for this series, which is Dr. Seck will be speaking for roughly 30 minutes, to be followed with a Q&A conversation between Dr. Steele and Dr. Seck. And the last 10-15 minutes, I'm going to open the floor for questions. Also, in order to facilitate the flow of the seminar, it would be really helpful if you have any questions to throw them into the Q&A even before Sara finishes, and then I can read out your questions at the end. Dr. Seck, the floor is yours.
Thank you very much. I greatly appreciate the invitation, and I look forward to our conversation. I'm going to start by sharing my screen. And so, as we've said, the title of my presentation today is International Law and the Ecologically Embedded Relational Individual. I want to start by situating the research and also myself, the researcher. The photo that I have here is from Nova Scotia. This is the Pennant Point Trail, which is quite close to where I live. I am in Halifax, Nova Scotia, as is Dalhousie University, which is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq. And we often say here, and this is a theme that I'll come back to, we are all treaty people. In terms of who I am not an Indigenous person. I am a settler. My parents were European, from England and from Germany, and they moved to Newfoundland and Labrador, to St. John's, which is another province in Canada and part of Atlantic Canada. So the photo that I have here is actually of the easterly most point in North America. This is Cape Spear in Newfoundland and Labrador, quite close to where I was born. And so as we talk about the research, I'm delighted to hear that Dina has taught the Revisiting Transnational Corporations and Extractive Industries piece, which is listed at the bottom here. I've included a list of a number of papers that I have worked on, which address in different ways the themes that I'm going to be speaking about today. And I shared with Cassandra the two that are noted in blue here. I don't have, as of yet, a book that puts all of this together, although I do hope to at some point. And so what is it that I'm hoping to put together? Well, the theme, as we've said, is international law and the ecologically embedded relational individual. And I'm working under the assumption that everybody who's listening has some thoughts already about international law, but perhaps less so thoughts about the ecologically embedded relational individual. So I'll start here. And the starting point really is the reality that the bounded autonomous individual, the liberal man, continues to play a dominant role in everyday thinking as well as in legal analysis, whether it's domestic or international. But of course, for a very long time, feminist thinkers in particular have been challenging that idea. And so in the papers that I've listed, I explore the work of a number of different writers, and there are many more who have inspired the writers that I refer to. So this is a big project, but in particular, I look at the work, the relational autonomy work by Jennifer Nadelsky, the vulnerability theory of Martha Feynman and Anna Greer as well. I look at the idea of corporeal citizenship, which comes from material feminist thinking, but as used by Dana Scott in work on toxics and environmental consumerism. And then finally, I examine the work of Angela Harris, who takes the vulnerability theory, bridges it to an ecological vulnerability idea, while noting at the same time the importance of appreciating and understanding difference in terms of how each of us is situated. The theme of difference continues as I look at the work of, in particular, Indigenous feminist and Indigenous environmental justice scholars. And I have a list here. Janice Makokis has written some beautiful work drawing on her Cree knowledge. Deborah McGregor, Anishinaabe. I haven't in these pieces yet referred to the work of Sherry Pictou, who is a new colleague of mine, but her work I think will fits beautifully again in these themes, and so on. So from the settler colonial and Indigenous feminist work, we have different views that challenge, again, this idea of the bounded autonomous individual, and also reinforce this idea that we need to understand that we are all differentially situated due to colonial histories and presence. Yet at the same time, we are all also what I call ecologically embedded relational individuals. And so what are the implications of this, and what does this mean? My broad quest is for a world of local and global, what I'll call socio-ecological justice. And the aim is to realize a vision of this kind. I think to do this, the first thing that is essential is that the bounded autonomous individual must be confronted at every turn. It is simply not true, and we have to make that clear. And yet when I say we, I note that we must at the same time be very careful to avoid what is I sometimes refer to as the universal we. We are not all the same. We are not all situated in the same way. There are colonial histories, there are differences that are crucially important for us to recognize, which includes, of course, different consumption patterns around the world. So the key questions then, I think, to ask are, what patterns of relationships do we wish to nurture? And this includes between peoples and the material world. And I go back to my first slide and just this recognition that we are all treaty people, yet at the same time, it's important to avoid what can be called pan-Indigenous assumptions about what that might mean. And so certainly in Canada, the idea of resurgence of Indigenous laws is ever increasing importance. And I think this is very definitely a part of the puzzle. I put a second question, which is, what relationships do we have a responsibility to nurture? If I look at the work of Deborah McGregor, and she's written a fantastic chapter on Indigenous environmental justice in this, as one of the framing chapters in our Cambridge Handbook on Environmental Justice and Sustainable Development. And I also refer to some of her other work in the other papers that I've listed there. But she and many other Indigenous scholars note first the fact that Indigenous laws are specific to each nation, but in many, there is this idea of reciprocal relationships with the natural world, with ancestors and with future generations. And she talks about the problem, for example, in her work on water, of waters having a responsibility to humans that the waters are not able to realize if waters have been polluted. And so there's this, I think, the idea of reciprocal relations that we see in Deb McGregor's work and in others perhaps suggests a different realm of relation and responsibility that goes beyond what many of the writers that I note on the first page sort of talk about in terms of ecological relationality. But then building on this question, what relationships do we have a responsibility to nurture? This leads to the question of, do non-Indigenous peoples have different responsibilities? And if so, how might we understand what those are? Again, we are all treaty people. We are all part of families. We're all part of communities. We're all part of ecological systems. So where does that leave us? And so now I turn to action. Okay, if we want local and global socio-ecological justice, and we think that there is a problem with this dominant bounded autonomous individual appearing all over the place as a construct, or as we'll see, informing even how we understand international law, then what should we do? And I believe active reimagining is required. We can call this conscious reconstruction or performance, while at the same time recognizing the importance of creating space and enabling voice from those whose voices have been taken away by colonial systems. And I think we need to do this for every field of law and every construct. So what might this mean? Well, in terms of reimagining legal fields, I've taken a few preliminary steps to try to think about what this might mean. I have one paper that examines the difference between, or the silos between labor law and environmental law, and notes that if we were, for example, in the Rana Plaza factory collapse disaster, if the response had been to conceptualize the worker in a broader fashion, then it wouldn't simply have been to address the collapse of the building and therefore building safety, so that we have workers who are sufficiently healthy to continue as sort of cogs in the wheels of capitalism. The worker can and should be understood as an ecologically embedded relational individual. And if you do that, then you can bring in not just, again, building safety and not just basic workers' rights, but also the importance of understanding that a job that is good for a worker is only good if it's also good for their family and their community and the ecosystem in which the factory is based. and also planetary systems, if you have things coming from other places and emissions going other places. So reconceptualizing the worker, I think, transforms how we understand not just the worker, but how we understand what the work is that should be done in a field like labor law, and brings it closer to a field like environmental law. Now, environmental law, we can do similar things, and I won't go into detail on all of these because I suspect I'll quickly run out of time. But for environmental law, one of the challenges has been seeing and thinking of the environment as different and separate from humans. But of course, if we understand humans as ecologically embedded individuals, then they are part of the environment. And so this again changes what the goal is and how we should understand what we're doing in environmental law. The idea of having protected areas that are entirely separate and apart from humans doesn't make any sense if we understand the ecologically embedded relational aspect. We need to understand the relationships at play and not build boundaries between nature and the human. In human rights law, I think we can see that often the assumption is that the human is this bounded autonomous individual. And yet if we challenge that and think of the human as ecologically embedded, this I think gives force to the idea that certain kinds of rights must be understood as crucial to the human rights project, including, of course, substantive rights to a clean, healthy, and safe, clean, healthy, sustainable environment, and so on. I'll skip for the moment the business law point, but just note that one can take these ideas and apply it to how we think about corporate directors, investors, consumers, and also how we think about the corporate form itself. And this can change how we understand the possibility of enterprise versus entity liability and how we think about supply and value chain responsibility. So my claim then is, or a question, should reimagining individuals and legal persons as ecologically embedded, differentially situated relational beings inform legal analysis of duties and responsibilities? And I would say including what, perhaps, and how we teach law. Finally, to the crux of the matter for an international law panel is, what does this mean for reimagining international law? And here I note again that the bounded autonomous individual has essentially infiltrated international law in the construct of the sovereign state. And the sovereign state pretends then to be able to live well independently and behind sovereign walls. But of course, this is impossible. Yet you can see it informing things like the Trump wall, border wall, and the Brexit movement as well. So what can we do to reimagine international law? I draw heavily on the work of Karen Knopf here and informed by others as well, but I have 4 key messages. First, that international law assumes the state as the primary actor. And this is, we can see this in that bounded autonomous individual is how we understand the state. But this, of course, dilutes what I might call cross-border non-state actor voices. And so there are a lot of things you could say about this. I'll give one example, which is the UN Declaration on the Rights of Indigenous Peoples. We should, I think, understand it as not understand its normative force, not just through the eyes of states, but also through the eyes of Indigenous peoples. And so if we reimagine international law to understand that cross-border non-state actor voices are also crucial players in international normativity, I think this can change our analysis, for example, of customary international law. A second point is the territorially bounded state, which is also something that flows from the image of the bounded autonomous individual. This, I think, silences the interdependence that there is between states, and also the reality of embeddedness of state to state in transnational economic relationships and transboundary ecological relationships. So I argue we should replace what I call the E word, the word extraterritorial, And every time we think we're about to use that word, we should ask, what is the nature of the relationship at issue that we're talking about here? And this, I think, again, changes the analysis. It changes what we are arguing. It changes how we understand what we are arguing. A third point is seen in the bright line or boundaries that exists within international law, whether we're looking at state responsibility and attribution rules, or whether we're looking at doctrines of sovereign immunity, boundaries between public and private actors. I think these boundaries enable states and state-owned enterprises to hide behind sovereign walls. It inhibits ideas of shared responsibility and duties of cooperation from really coming to the fore. We also see bright line boundaries between international and domestic law, and this is particularly so in dualist states. And also, I think, this boundary idea between international and domestic plays a part in how we understand the international obligations of non-state actors. I think we're overcoming that in part with, in Canada, we have the recent Nevson decision, and also perhaps through things like the UN Guiding Principles on Business and Human Rights. So the bright line boundaries is number 3, and number 4 is the idea of the unified state. States are not unified in the way that the bounded autonomous individual might suggest they are. And if we can step back from that and understand they're not, then this increases acceptance, I think, of overlapping yet interdependent sovereignties, including Indigenous sovereignties, and perhaps opens the door more to ideas of polycentric governance. So in conclusion, I would say, first, there's a lot of reimagining to be done. I've only taken some preliminary steps in this way, particularly focused on ideas of transnational corporate responsibilities for climate justice in the piece that Dina noted, as well as some others. But I also note that climate change and climate justice is just one example in our time of global ecological crisis. There is an interdependence between climate change and biodiversity loss, problems relating to toxic substances, plastics in the circular economy, relationship with oceans. And so, as I say, there's a lot of reimagining to be done. And I look forward to hearing Cassandra's reflections and your questions. Thank you.
Thank you very much, Sara. Thank you for this very thoughtful presentation. And before I give the floor to Cassandra, I want to say how much I enjoyed the fact that you acknowledge so explicitly your influences, and you even put them in the slides, right? I think it's a way of doing what you're saying, apart from only saying it. And I think I'm going to stop talking now, and I'm going to give the floor to Dr. Stia to chat for the next 15-20 minutes.
Thank you, Dina. But thank you for the invitation, actually, Dina, to be part of this conversation, because I had sort of seen some of Sara's work, but it's amazing to be able to engage with you, Sara, on it. And indeed, that the positioning yourself as a researcher in your research, I think, is a really great starting point. So I'll jump off that, Dina. It's something that I try and encourage PhD researchers to do as a matter of course. In terms of their research design, because we always bring with us like critical subjectivity is necessary. Always bring with us who we are as a researcher, our gender, our ethnic background, our language and linguistic background, our political beliefs. And I try and encourage PhD students to think about how that might be affecting how they're asking questions and the kind of solutions they're asking to get rid of blinders. But it's obviously of particular importance when engaging with relational law and Indigenous perspectives. So one piece I wanted to pick up on in particular is if you could say, so I have 4 questions for you, so just to give a heads up. So the first one is, if you could say a little bit more about what it means to say we are all treaty people. So for context, in Australia, we don't have a treaty with Indigenous Australians, and it's one of the things that that Indigenous Australians have been calling for decades. In the Uluru Statement to the Heart from a couple of years back, it's one of their actual political calls for action right now is treaty. So we don't have a treaty, so we lack the ability really to say something more meaningful about that, and there can be problems with having a treaty as well. So if you could say a little bit more about that and how that links into also the problem of seeking to avoid pan-Indigenous assumptions. And I'm going to say a few more things off the back of your answer.
Thank you for that question. So to be perfectly honest, the reflecting on really the meaning of we are all treaty peoples is somewhat new for me. And this is perhaps because I have now lived in Nova Scotia for just under 4 years. And this is language that I hear here all the time. And in Nova Scotia, there are underlying peace and friendship treaties in which the land was not ceded. And so in the Nova Scotia context, it's particularly important for me to reflect on that as I am here. But in the broader Canadian context, for example, there are old treaties, historic treaties. There are also new treaties in other places, and there are places where there are no treaties. So there is sort of the full spectrum of those. And I guess because there is sort of the full spectrum here, it seems to me that the idea that we are all treaty people nevertheless applies even if there actually isn't a treaty, because even if that agreement hasn't been reached, the fact of colonialism, the fact of the settler-colonial relationship still exists. And so perhaps it's even more pressing to understand that it isn't just a problem for Indigenous peoples, right? But that those of us who are here living in the space where there are Indigenous peoples are part of that system and part of that relationship. And we can pretend we're not, right? And sort of put the burden of sorting out the rights and responsibilities on Indigenous peoples, where we can try to understand that this is actually part of our relationship, right? It is who we are, those of us who are non-Indigenous. We are part of a system in which there are these relationships, and we need to grapple with that.
That's really helpful, thank you, because it comes back to situating ourselves again. So this problem of pan-Indigenous assumptions, to give you a bit of a context about the research that I'm really just starting out on now, to look at how we can incorporate Indigenous knowledge and governance and law into space governance. So some of the key problems in space governance and space law are environmental problems. The amount of debris that we have in orbit around our Earth is just unmanageable and getting worse literally by the week, because we're adding more and more launches and satellites to that. And that debris is a problem for two reasons. One is we are so dependent on space-based technologies, and any piece of debris the size of a fleck of paint could be lethal to a satellite that's providing critical communications or health services or any number of things. But the other reason is because we also need to think about, I argue, our near-Earth environment as part of our natural environment. We're in it, we're dependent on it. You know, the problems we have with climate change means that, in fact, we are getting literally physically closer to that near-Earth space environment as our atmosphere thins. And so we need to be thinking about its inherent value and intergenerational responsibility with our use of it, and long-term environmental management. And it seems to me there's an obvious answer here in Australia, where we have a culture, a living culture of 60,000 years where these people have been managing the environment for long-term sustainability and for intergenerational responsibility. And very much part of those key concepts in my very rudimentary understanding of Indigenous laws here in Australia is that law and identity are caught up, they're integral to each other. And so relationship to country, relationship to water, relationship to the cosmos, and the responsibility to manage those environments is all part of identity, and there are laws around that. But one of the problems that I face being so new to this, really, as a non-Indigenous Australian as well, is assumptions of the stories that I hear being Aboriginal Australian stories rather than particular nations. And there are lots of overlaps between the stories across nations in Australia. And also people, the immediate response I get from a lot of very interested people when I tell them what I'm starting to work on is, oh, well, you should look at what's going on in Hawaii and Canada and New Zealand. And I'm just wary that the assumption is as soon as we say Indigenous, It all has to do with this wonderful connection to Mother Earth, and that will be the answer when there are so many cultural differences across all of these nations. And so I'm wondering if you have thoughts about that. So there's not only the question of our responsibilities as non-Indigenous people, but also how we're interacting with and learning from the multitude of Indigenous approaches to these questions and to relationship and identity and law.
A great question. So I've thought and struggled, I guess, with a lot of these similar questions over the years, and I can at least share where I am at this point. So the first point would be the reason I know that it's really important to avoid pan-indigenizing is because my Indigenous colleagues are very clear about this, and Indigenous scholars are very clear about this. So if you look at, for example, in the writings that I have, if you look at how Janice Makokas frames what she says about what the teachings are that she has learned as a Cree woman, she is very clear, this is coming from my culture, and this is very specific. Deb McGregor, exactly the same thing. This is an Anishinaabe view in her chapter, in all of her writing. It's very clear. This is specific to my nation, and I will not assume that this is the same in other places. And yet there is also sort of a recognition that for many Indigenous peoples, there are similar ideas. So I respect the views of those who are Indigenous who say that avoiding pan-indigenizing is crucially important, and that I think is the starting point. The trick, I think one of the things that I've really struggled with as well is there can be a tendency certainly in some of the work that goes on in perhaps more popular media circles or ways in which Indigenous knowledge and is talking about, and maybe this comes from sort of the settler colonial kind of template, to say that Indigenous peoples have these, pan-Indigenous, like all Indigenous peoples have these special things, right? These special relationships, the reciprocal, and da-da-da-da-da, and settlers don't. And that, I think, is where we have a problem, because we can't solve the problems that we face by saying that this is something that Indigenous peoples have this special knowledge and understanding, and therefore it's kind of over to them to solve the problems, right? So we definitely don't want to do that, because that's not fair, that's not right. It places the burden on Indigenous peoples, Indigenous women in particular, in some contexts. So that's also a no-go. So the question then becomes, how do we understand, how do those of us who are non-Indigenous but conscious and concerned about ecological issues, how do we claim or use or engage with that knowledge without being accused of appropriating it, right? Because that's the other piece. If we say, okay, I'm not going to place the burden on Indigenous peoples, we're going to do the work ourselves, or I'm going to do the work myself. How can I do that, right? Because I'm a settler, therefore I'm not supposed to have that knowledge, understanding. And this is where I think it gets really interesting when you actually look at feminist voices and feminist materialist voices and others. One writer who I've become, one international lawyer who I have engaged in recently, is known as the Mother of the Oceans, Elizabeth Mann-Borghese, who for a time was on faculty here at Dalhousie. And I was asked to write a brief sketch about her as a woman in international law. And I have to say, I am blown away by her writings and the relationality which is in there and the work that she did in terms of, anyway. So the point, I think, is to say that I think it's crucially important to engage and to appreciate Indigenous knowledges, and to work with and engage with different nations and colleagues, and to work towards decolonization and reconciliation and all of those different things. But I think while we're doing that, it's also really important that we acknowledge that the bounded autonomous individual man that is seen as the dominant view in Western thought is not actually something that ever should be associated with the dominant view in Western thought, because, you know, what about the history of women who challenged that view? Or like, are there other ways that we can get at that? And that's where I'm sort of at and stuck.
That's a really, again, extremely helpful way for my own research individually, but I think just in terms of thinking across these boundaries, is that there has to be, so the call that I think is starting to get more and more listening and respect in Australia is for co-creation. So Indigenous-led research, Indigenous-led projects, and then co-creation, because there is knowledge to be shared from across the world. So from my settler world, but from the privilege I've had to access to legal education in various different countries around the world, there is knowledge I can bring to that, and that perhaps I can more appropriately speak on behalf of. But that co-creation, I think, is at least that's where I see that the access perhaps is. It's you know, being very careful not to appropriate and not to have pan-Indigenous assumptions, but also not to assume that I have to then take on the burden of a history of international law or of law that I actually don't position myself within. So I think co-creation is one way to think about it. And that led me to think, so this was part of my third question on active reimagining. When I was reading your piece on relational law in particular, it led me to think, in fact, there are some more traditional Western theories of international law which overlap a lot. And I'm thinking of critical legal studies and New Haven School in particular, both of which, you know, the scholars have been predominantly white men. And there are assumptions within both of those theories which are quite traditional and liberal, but there are also some helpful tools in there. And that's where this crossing over of worlds can perhaps happen more. So in critical legal studies, where the crux of it is that international law or law is just what lawyers do or judges do. It doesn't exist out there. It's something that is enacted. And therefore, our individuality, our positionality is part of how we do law. And that's quite a useful perspective, and the language that's been developed by the crits. And the other in New Haven, which is a school of thought that I was quite enamored by and incorporated a lot into my PhD and my book. So I tried to separate myself from some of the ways that New Haven has been used to justify the state with the most power being the one that just makes international law by being and acting a certain way. But the tools of New Haven are also quite similar, which is to say it's not just the state that makes international law. There are many, many participants in that process, and it's a political process. And if you have sufficient authority and a sufficient power to enforce that which you assert as law, well, then you're a law creating participant. And there are problems with that in terms of it's, you know, ultimately it's still those who have and maintain power who get to maintain the status quo. But if we're using all of those tools from these other Western schools of thought and their crossovers, I wonder if that's part of the active reimagining, or does it just then get too messy?
So that's great. I've also been, you know, enamored at times with New Haven and also with the crits. So we're definitely on the same page here. I think the active reimagining, I mean, I think one doesn't, I don't know, an expression you can use is, you know, you use all the tools in the toolbox, right? And you try to figure out how to engage in different ones in different ways. And you don't throw it out because it's, you know, because it's white male at all, right? The question is it relational? What are the relationships that are being explored in our, you know, is the work exploring relationships and taking them seriously? And then, of course, maybe it's exploring relationships, but not taking power or, you know, colonial history as seriously as it can or should. But I think relationship is really a key starting point. There was one, I just lost my train of thought for a second. Where were we? So what to do with this, and then
so I guess I was asking, is it too messy if we start incorporating all of that? But just, yeah, I mean, as you said, there's different tools and language developed in these other theories. How to incorporate those, not, well, you know, this co-creation idea, I guess, as well.
Yeah, Yeah. So I will say first, the co-creation, I think, is absolutely the right path and tool and way to think about things. I guess this is where I was going, was one of the things I also struggle with, and maybe you have some thoughts on this, is the, I guess, the act of engaging, the act of scholarly work, but also the act of engaging in other non-scholarly work, which I do periodically in different ways. And being conscious of the performativity of that, right? So it could be that the New Haven, for example, in the example that you had given, that you have scholars who are doing analysis and then making the claim that X flows from certain states having power. But it seems in the act of actually examining the lay of the land and describing it, we also give power and we take power away. So one of the things, and I think this is, so I use again the example of the UN Declaration on the Rights of Indigenous Peoples, which when we describe it in a way that is a state-centric analysis, it is only a UN General Assembly resolution, therefore it is non-binding. We take power away from a view that would say that, well, actually, because Indigenous peoples worked together from different nations over the course of decades, and brought this forward to the United Nations for recognition of their existing rights, right? Not to say we don't have these rights until you say we have them, right? But to say, these are our rights. You need to acknowledge them, right? That's a different story and a different vision from one that starts with the state. And so if you tell the story starting with the state, it's a different story than if you tell the story starting with others. And I think you can say that in a lot of different contexts. So it's understanding the relationships, and it's also understanding the role of the lawyer and also the legal academic in telling the story. Whose voices do you give power to? And whose voices do you take power away from? And this, to me, the question and the part I struggle with, right, is the role of criticism and engagement, right? So our typical legal scholarly approach will be, some new instrument is developed and then we critique it, right? We say, well, it should have said this and it should have said that and it should have said something else. But in the process of saying it should have said this and it should have said that and it should have said something else, we've actually undermined the ability of somebody to interpret it and say, well, it doesn't explicitly say this, but it must be read so as to say that, because otherwise it does not fulfill whatever the vision might be of those who need it to say that. That's sort of where I've hit on that, but I don't, anyway, is that crazy?
Again, it's really, really helpful. So I'm aware that we're pretty much at the end of the time that we have to discuss, but I wonder if I can just throw one more question at you, and then maybe that can lead into more questions from people, which actually links that it has to do with language. And Dina said to me before we got onto this webinar how much she appreciated your writing is excellent to teach from, and not all scholarly writing is, right? Like sometimes it's just really nitty-gritty deep theory that's very hard to teach from, but your way of conveying, here is where the literature is at and here's what I want to add to it is actually very accessible. And so that has to do with language, and a little bit to what you just said about interpreting. You speak in your piece on relational law about avoiding universalizing language, avoiding the E word of extraterritoriality, and replacing it with language that has to do with responsibility, relationship. So the question I want to ask, because I published a piece recently that is a feminist analysis of space law, the province of all humankind, which basically uses liberal feminist tools, again, using the kind of more traditional tools to say, linguistic activists, feminist linguistic activists have changed a lot in the language of the law in order to change their reality under the law. And that's what we need to start doing in space law, simply because we need to open up the space sector to more diversity. So I was trying to reach a specific audience with that. I was specifically not going into an in-depth theoretical analysis. But still some of the response back is, yeah, but just changing a word doesn't make a difference. And I'm wondering whether you agree with that, or whether you think linguistic activism does make a difference.
So, so the E word is a prime example, I think, of this. I have over the years convinced some people that this matters, and others that it doesn't. The reason that I started worrying about it was anecdotal. In Canada had roundtables on the responsibility of mining companies operating internationally, which came as a result of first a standing committee report, which said Canada must do something to regulate its mining companies operating internationally, and never uses the word extraterritorial, followed by a government response, which basically says, we would love to, but we can't because it would be extraterritorial. And you see the word extraterritorial all over. And once you start paying attention to that, and I started paying attention to that listening to discussions over the Alien Tort Claim Statute, those who thought, you know, leading into the Kiobel decision, those who thought that, you know, Kiobel absolutely should be heard, never used the word extraterritorial. And those who thought it shouldn't, used the word extraterritorial all the time. It matters. That word matters. And I think it matters because extraterritorial is binary. Territorial, that's legit. Extraterritorial, ooh, that's questionable. Illicit, we're not so sure. But if you toss that word and actually say, what is the relationship that we are talking about? It's a transnational economic relationship that is pre-existing. Focus on the relationship. Don't reinforce imaginary boundaries. So I think in that context, I'm quite convinced that the word matters. And I think in other contexts, it may as well. But having said that, if the word is there and you need to interpret your way around it, then that's a different task, right? And unfortunately, the word extraterritorial is all over the place. But one can, you know, interpret around it. Just use the word extraterritorial when you must, and the rest of the time describe what's going on using other language. But,
fantastic. Thank you, Sara. That was, and I'm one of the people who you did persuade that we should avoid it as much as possible. So I can bring testimony to that. Thank you both very, very much. We have roughly 10 minutes. So I think I might move on to the audience questions. And then if there is some time, I'll open again the floor to Cassandra. So Peter Zighetti, is asking basically, so the question of Peter is about basically the dark side of relationality. So the question is, having read Jennifer Nedelski's work carefully, the call to get rid of bonded liberal subjects seems disingenuous to me. Feminists have spent 100 years arguing for basic rights, which all presume the acceptance of women as independent subjects. And basically, the relational approach seems decidedly conservative and male chauvinist to me, to Peter, looking at women primarily as mothers, daughters, people with special obligations towards God, towards nation, etc. And he also concludes by saying, likewise, a relational approach to environmental protection does not guarantee any greater protection of the environment than a liberal one, it seems to me. So yeah, to also add to Peter's question, yeah, my question, I guess, would also, to build up on Peter would be, what about the resurgence of approaches that are not liberal and they are relational, but the way they build relationality is not the way you're thinking about it, you know, because like I think it would be different having this conversation in 1995, and it might be a little bit different having it in 2021 with like the rise of ecofascism, right? So Sara, if you want to.
Great. So a couple of points. I think the Relational autonomy, which comes from Dalhousie, is actually crucially important. So it's not getting rid of the autonomy, it's just understanding that autonomy only exists. One is only autonomous if one is surrounded by relationships that nurture one's autonomy. So autonomy still matters, but you understand that autonomy comes from one's ability to realize one's autonomy is a result of relationships. And that is actually just fact. And it's not about men or women. That's just, there is no bounded autonomous man who didn't have a mother or a family or anything else, or a father, or, you know, a community, and so on. The other is, so I really think that's crucial, right? And the other thing is, this isn't about stereotyping women, right? Because if you see in all of this, I'm not saying women are different. I'm saying everybody is ecologically embedded and relational. Men are, women are. Those who are neither men nor women are equally, right? It's gender diverse people, everybody. So that's my sort of first response is this, I think what I'm saying is a bit different from what's being understood. And then other ways, I mean, I think there are lots of other ways. I always see this as a piece of the puzzle, not, there are no silver bullet solutions. So I hope that's helpful.
It is it's extremely helpful. Thank you so much, Sara. The other question I have from the audience is from Gary, who is situating partly the question in the Australian context that Sara might not necessarily be so familiar with. Gary says, once the reimagining is done, what happens then? And the context of that is Australia's legal system seems a fair way away from wanting to acknowledge that different laws or relational identities exist in this country, let alone any responsibility to overlapping sovereignties with our neighbors and their identities. In fact, a lot of countries seem to cling pretty tightly to their bounded, autonomous, sovereign identity. And again, to riff a bit off Gary's point, I think what I really like about your work, and I was wondering if you can explain that a little bit more, is that you do have practical ways of doing this reimagining. And I really like this, that there is this very high abstract theory, but then you're like, and therefore we should prefer this document over that document. If I could invite you to talk to this point a little bit.
So yes, I'm a pragmatist at the end of the day. What can we do with this? I like the ideas, but I think trying to figure out what this might mean does really matter. And so I think I don't think the process and the process of reimagining is not something that's easy or simple or something that people are going to buy into quickly, right? But I think the point, in a sense, is just to challenge every time the bounded autonomous individual seems to inform a doctrine or a way of thinking about things. And if this is done often enough over time by enough people, then there will be change. I draw that hope in part from a super interesting paper by Nick Blomley on property and performativity that I read quite a number of years ago, but I found that incredibly interesting. He talks about how even the process of building a fence with his neighbor performs a bounded understanding of property. And so, and then he talks about all these other things that sort of perform this bounded understanding of property. And so I take from that in part, again, that it's just what matters is to think about this and to identify it and to challenge it and to try to constantly sort of reiterate that. And then over time, there may be change, but it isn't a magic wand silver bullet. It's one has to change social understandings, and that takes time.
Indeed. we have a couple of minutes left. So Cassandra, because I cut you a little bit earlier, if you have anything to add or anything to ask Sara, I think you should absolutely, you don't have to, but you should feel free to do so. Otherwise, I think also because it's very late in Nova Scotia, we might as well thank Sara for this fantastic presentation. And I think I speak of everyone in this meeting to say that, you know, it gave us so much to think about. Thank you very much for your time and for your generosity, and to also thank Cassandra for such a close reading and engagement with Sara's work. This is exactly the sort of thing I was hoping to happen when I was putting together this series. And before we say goodbye, I want to remind everyone that our next seminar will be in 2 weeks' time. I believe that's the 4th of June, when Dr. Surabhi Raghunathan will be talking with Professor Don Rothwell about lawmaking, world making at the sea. Thank you very much for coming, and thank you very much for sharing these very insightful thoughts with all of us.
Thank you very much. I greatly appreciate your comments and reflections, Cassandra, and Ntina, for the invitation. Thanks so much, everybody.
Thank you for staying up so late. Bye.